If Congress wants to change this, just go amend the statute. They have some power. They can just go change the law. Why don't you just go pass legislation that says, actually, we're gonna go amend the statute and say for cause means this. Only if Lisa Cook is convicted of murder, then you can remove her. Congress can change the law. They wrote it, but they don't want to do that, okay? Because they're pathetic.
Why did she take these 2 mortgages out? She took out a Michigan loan, and then 2 weeks later, she goes and she takes out another loan for a property in Atlanta. She declares both of them as her primary residence. Then you go back 4 months from that, she took out another loan. We're now finding on a 3rd property.
Lisa Cook is looking shook. She submitted this motion here in a reply to President Trump's firing, essentially, of her, saying you're removed from this position unless you resign. She didn't resign and she needed to go. She didn't explain herself in any way, shape, or form, still hasn't to this day, about why her mortgages all say primary residence in multiple locations. And she got them back to back and then suddenly is just being mum about it. And we've got questions about her propriety and her integrity, and she's refusing to answer it because I guess she's better than us. But this is her reply in support of her motion for a temporary restraining order. Now, she wants President Trump to be stopped from the firing, and she submitted this. You know, the government, Trump, as it must, they agree with us that the president's removal power is limited to for cause, right? And we've been battling over this word. What does for cause, this phrase, mean? What is the definition of cause specifically? And does it cover anything Trump wants? They want the standard to be very tight and narrow, okay? So that for cause means you have to be convicted of a felony and have exhausted all your appeals to the Supreme Court. And only then is that cause and you can be fired, right? Same type of garbage we see with the illegal aliens. They say same thing about them. Well, you can't deport them. Well, they're here illegally. Well, but they haven't killed anyone. Like, well, that's not the standard, weird people. Same here. It says for cause. We've already read through Trump's response to this request for a TRO, where he explained it very clearly. And so she says it doesn't mean that he can, fire me, essentially. Now, similarly at odds, she writes, the government would reduce the right to a notice and hearing. Okay, so now she's acting like she has been charged with a crime. You get charged with a crime, you got to get notice of that. You can't be prosecuted if you have no notice of something and you just show up like, oh, you got convicted of, you're guilty of murder. What? I didn't even know. That's not due process. But she is not being charged, not yet. And if she does, Pam Bondi's got the criminal referral hopefully sitting on her desk, not next to the Epstein files in a safe place, then she can file and make her complaints in other districts. She can go over to the Court of Federal Claims. Trump responded in his reply saying, I've got cause. If you don't like my firing, if you think that she was damaged, she can go file those claims. The government is referencing this case, the Reagan case, which says that the president's decision to remove somebody is unreviewable. But they say, well, let's look at the text. The government's argument that Trump and his decision to remove a board governor for cause, they say it's unreviewable. Well, that cannot be squared with what happened in Trump versus Wilcox. The Federal Reserve's independence would come to a screeching halt if you allow this to happen, and the president would be handed blanket permission to unravel the foundations, look at this, of a unique institution with a unique historical background. Is there a unique institution or historical background clause in our Constitution anywhere? It says, well, you can create fake executive agencies as long as they're unique with a nice historical background. What the heck is that? It's a special arrangement sanctioned by history, okay? It's like platitudes. And that was from Alito, who is dissenting in a different decision. Congress wanted, and this is wild because if Congress intended this, like literally, they could have written it in there and they didn't do it. They didn't say for cause only if you're convicted of a crime or for cause if there's preponderance of the evidence standard and you have a notice and hearing. It's not what the law is. It's for cause. It's the president. You can't shackle the president. Otherwise, the person who's shackling the president has more power. And that is constitutionally illiterate. That's not how our system works. In enacting the Banking Act, they say Congress expressly rejected proposals that would have granted the president complete control over the Federal Reserve Board membership. Okay, so that is not even a relevant parallel. Trump's not trying to exercise total control over the Federal Reserve. And so they're introducing debates from the original passage. And they're saying, well, some people will, and during the debates, doesn't matter. The law says for cause. Thanks for your argument. As the court standard in Humphrey's executor, which hopefully gets overturned by the Supreme Court, this is what we're talking about. They said in Humphrey's that we really should interpret for cause, the Supreme Court says, only for inefficiency, neglect of duty, or malfeasance in office. And when we talked about this previously, we said you could check the box for any of those things as it applies to Lisa Cook. Inefficiency, neglect of duty, she should have reported on both counts, hey, I've got this thing that might be a problem. She didn't disclose it to the Senate during her testimony. And malfeasance in office, she was paying the mortgages, these fraudulent mortgages, I presume every month. So is that not a perpetuation of the fraud in office? Now, they're going to say the Supreme Court has suggested that for cause and other things are synonymous. Then there was some amendments, and the Supreme Court recently made clear, now we get to some new stuff, that any for cause safeguards the agency independence must apply with particular force to the Federal Reserve. And I don't think they really said that. They did make a note, okay, because in this Trump versus Wilcox case, like I think this is not really accurate, it's kind of dishonest, which is not a surprise coming from Abby Lowell, but they didn't actually say that per se. Remember, Trump versus Wilcox, Trump fired somebody else, and the Supreme Court said, you can do that because you're the president, you know? And the argument back was like, well, we have all of these other entities that are independent executive agencies, essentially. We've got the, Merit Service Protection Board, or the Office of the Inspector General. They fired Dellinger, they fired Wilcox, all these different people. So they said, well, if you can fire us, then they're going to come after your sacred Federal Reserve. That was their concern, and they were filing that in these cases, Trump versus Wilcox. You can't do the Supreme Court. Think about the compounding effect. It's just going to trickle down to all of the other agencies, and they're all going to get nuked. Yeah, we know. The court in Trump permitted removals of the National Labor Relations Board. Remember, because this National Labor Relations Board was set up to be insulated against the executive branch in America, and that was unlawful. And the courts came and said, yeah, sorry, they can go. So in 1972, the Federal Reserve General Counsel said some nonsense, and the Supreme Court in 2021 also stated that the for-cause removal restriction for the FHFA director appears to give the president more removal authority than statutes specifying particular bases for removal. But the court had no occasion to definitively interpret any of this, and so now here we are. Now, the government is saying that they can come up with any articulable justification that the president deems sufficient, except for mere policy disagreements. Yeah, it's called cause. If the president has cause, he's the president. And if you don't like that, well, then you can sue as you're doing. You can go into the other courts that have been set up for your firing complaints. Congress can be saying, this is outrageous. Trump is breaching his obligation to take care of the country and execute the laws. And they can impeach him or do something like that. But what we don't want is Congress to delegate their responsibility, okay? If they don't like what the president is doing, their check and balance is impeachment. They don't get to be big babies and just divest themselves of the responsibility and give it over to independent agencies that are insulated from any political accountability, because that's their job. And so mere policy disagreements is not even being debated here. But if you have cause and a policy disagreement, that's the president's prerogative. It's one executive agency. Congress can't outsource this stuff to third parties. And that's been happening for decades, since 1913. This position leads to an absurd conclusion, they say, that the president has dramatically more power to remove people from the Federal Reserve. And I don't think that's the argument. It's the same power. It's the presidential power across the board. Remember Selah Law, we covered that case. CFBP, we covered that case. And now the government says that cause cannot encompass mere policy disagreements. I would say, I think it could. I mean, it doesn't say for cause except for policy disagreements. Again, if Congress wants to change this, just go amend the statute. They have some power. They can just go change the law. Why don't you just go pass legislation that says, actually, we're going to go amend the statute and say for cause means this. Only if Lisa Cook is convicted of murder, then you can remove her. Congress can change the law. They wrote it, but they don't want to do that, okay? Because they're pathetic. They'd rather just outsource this stuff. And we don't want that to happen, because all that does is seed other oligarchical bodies that seize control of our political process without any accountability, and Congress must do better. The government argument only works if they relied upon a dictionary definition. And I think it actually is broader than what even the DOJ is saying. But they say that the prevailing understanding of cause at the time that this was enacted was almost exclusively for conduct undertaken in the course of the office, okay? So she says, I committed my mortgage fraud before I got the job. What's your problem? Pre-office conduct was generally not grounds for removal. So she could have embezzled $1 billion and there's nothing you can do. It's just, it's her. And wait a minute. Financial improprieties are a big problem for somebody who's on an institution trying to secure our financial propriety. Seems like it's a problem. So they go back, they go through the canonical English case. They go back to 1758 over in England. Pre-office conduct is addressed through the vetting process and the impeachment process. All right, so then Congress outsources this stuff, and then you expect Congress to go check the branches, these fake branches that they set up, to check the power that they delegated to them? Okay. And they don't want to make hard decisions. Like, that's a hard decision to make. Well, hey, I'm a Republican, and I think that Trump is firing, this is like a major issue for me, so maybe I will impeach him. And you start, wow, and that creates some pressure, and you have a check and balance and a separation of powers. You don't have this muddled gray area that's disgusting, because the grift exists in the gray. This allows the nominee to address the allegations, which she didn't disclose. Nobody discovered it until now. And so, well, you could have asked me about it and you didn't. And so I committed fraud, so it doesn't matter. And I got past the post. Now, even if pre-office conduct were considered against the broadest definition of cause, if we expand that out, the allegation on which Trump took his action is not cause. Okay, so they're going to address, hopefully, the charges here and explain what happened. The government mistakenly says that Cook's alleged conduct, which is making contradictory representations on financial documents with no explanation given, is cause. Now, even if the president's authority is for cause, you know, as the statute says that Congress wrote, even if it was comprised to a limited set of circumstances, it should be much higher. The standard is clearly not met here. Okay, so again, they're defining cause. Now he's saying cause has to have moral turpitude, or you have to have cause. I mean, if it's convicted, you're convicted of a crime. So give me a break. So the contradictory representations are not moral turpitude. They're not criminal convictions. And when you talk about crimes of moral turpitude, it's generally crimes of dishonesty, fraud, deceit, conversion, you know, all these concepts where it's not like a crime of passion. You have a self-seeking, dishonest interest in the offense. Instead, they are unsubstantiated, untested, and unaddressed allegations. If such unfounded allegations were cause, the president could fire a board member over mere policy disagreements, which I think he can. I mean, honestly, like, it's the president. There is one executive branch, and the shackles on this position are unconstitutional. So including the timing or an interest rate drop, but as the government concedes, that's not the law. You know, they're not trying to, I think, overturn the entire Federal Reserve right now, but not yet. And we've had conversations here about firing Jerome Powell as well. And let's just duke this whole thing out. Hans Mahnke made that tweet. Moreover, the asserted basis for Governor Cook's removal suffers from another legal infirmity. What is this? Well, the government has long known about these facial inconsistencies alleged in her financial documents. At August 29th hearing, the government conceded that if it was something that was known at the time, it's much harder to say that it's caused later because the presumption is that the judgment has already been made. Now, the contradictions were included in documents disclosed to the White House before she was appointed by the president and confirmed by the Senate. In fact, during her confirmation process, she submitted questionnaires and provided reports that would have revealed the same purported facial contradictions the government now claims to cause to fire her. Again, so as long as you get the fraud past the government, you're good. Just get it in there. Senators are idiots. They're not going to criticize you because you're a historic black woman, first one ever on the federal board. No one's going to have, you know, and actually it was a very contested hearing because she's illiterate as an economist. A proper hearing would demonstrate that the government had prior knowledge of these facial contradictions before the president invoked them, Trump, as the basis for her purported removal and saying this was known, like you already knew, so you can't now make it up as cause, which I think is just kind of sequentially out of order, right? Again, logically, if you can just get past the post, then you're good to go, is their standard, essentially. So in May, even if there is an appearance of impropriety later on down the line where the president has absolute for cause to fire you. So then they come through and they say, well, Trump wants her gone. And, right, they go through all Trump's posts. And, you know, we often say a lot about this. It's like, if you're representing a client, you don't want them to start running their mouths. Generally not good for your case. But, you know, Trump is the president. And so any words that come out of his mouth have a lot of weight, carry a lot of power. And so they seize on them and they say, see, this is evidence of other things. And if Trump didn't make these posts, if he didn't say these things, then they wouldn't be able to write these paragraphs. But, you know, the president, like, it's a lot a bit different than prior presidents to comment on these things, but it is the president and it's his job, right? This is what he should be doing, is governing and holding people accountable who are not performing well in his administration. So again, the fact that he's making comments on it, I don't think is an excuse to say that she cannot be fired because it has to be for cause. In other words, this is not for cause. This is just a mere policy disagreement. So what? Mere policy disagreements can be cause. What if there is a bad policy decision that's coming out of there that interferes with the president's duty to take care of the country? How do you have accountability for that in this system? You don't. That's the point. The court should accept the government's invitation and look at Trump's own words and evaluate him because he is just trying to fire her for a pretextual reason. Now, she is going to go on to talk about due process. Again, I know. Due process, it's like the word of the year. Together, these require notice and a hearing when the president wants to remove an official with for-cause removal protections. As Justice Breyer put it, who's irrelevant, the government's attempt to resist the well-settled rule fails, and more. Now, she possesses a property interest. No, she does not, in her position on the board. And again, with the reference to the historical pedigree of the Federal Reserve, which is a joke, and the special crucial importance of the independence of the board, the due process clause guarantees that she gets oral at minimum, oral or written notice of the charges against her, an explanation of the employer's evidence, and an opportunity to present her side of the story before she's fired. And then all of that, of course, is shackling the president from the presidential prerogatives to take care. And critically, both the Supreme Court and DC Circuit say that hearings must take place prior to the discharge. Now, she didn't get notice. Just 30 minutes before Pulte posted about this, Trump went on and demanded that Governor Cook resign. That's not proper notice. Sounds like notice to me. You guys knew about it. For starters, neither Pulte's post nor the government's response states that the president was considering removing her for cause. And without that notice, she was entitled to it, and they can't remove her without the due process protections. Now, she didn't get an opportunity to be heard, and Trump has said multiple times she must resign. But in the final section, Abby Lowell for Lisa Cook is going to explain how damaging this is. And we're not seeing emotional damage in this one like we saw with the FBI agents when they were suing Trump for emotional damages. We now have reputational damages because they all came from Trump, not from the fact that she has fraudulent mortgages. So here's what Abby says. The government asserts that the unprecedented removal of a governor should be treated like a regular run-of-the-mill employment case. Not really. He's got for cause. There's been a bunch of other, escalations of this. And he's the president, so he can fire key people under the executive branch because there's one executive at the top. To the contrary, this case is a genuinely extraordinary situation, in which the circumstances surrounding an employee's discharge so far depart that irreparable injury might be found. What is the irreparable injury? She got fired from her job. She's not entitled to a government position forever. To start, preventing Governor Cook from discharging her duties is irreparable harm. And that point has been rebutted many times over by the Supreme Court, right? In most employment cases, there is a background presumption, he even explains it, that jobs are fungible, right? You can swap them out. You're not like a special, it's not yours. And that the loss of a job can be remedied through back pay. But this presumption, right, the default standard, it doesn't apply to Lisa, a Senate-confirmed officer who has sworn an oath to ensure the stability of the financial system while she's committing mortgage fraud, allegedly. There is no remedy at law, whether back pay or something else, that can redress the harm that she will suffer if she can't be a public servant and carry out her obligations to the American people. Now, remember Secretary Treasury Scott Bessent. Dellinger was the Hunter friend, apparently went to law school or something like that. And then he sued, said, you can't fire me. They said, yes, we can. And he's gone. The court in Dellinger explained that the wrongful removal of Dellinger would not be irreparable harm because he would remain out of office for a short period of time. That was probably during the injunctive phase. Not so here, saying that she's going to be replaced. Says, Trump even said, we've got some good people for this position. Even Stephen Moran might be somebody. He's already been submitted to the Senate. Yeah, because she's fired. Yeah, you got to fill it, obviously. So she's gone. Trump has to fill the position. So he's working on it right now. So then she's fired. And so they're saying this is going to be devastating for her. And they also say, by the way, the Dellinger case is non-precedential. Almost every court saying you can't rely on that. And in other cases, this court has reiterated that injury is irreparable when they're removed from congressionally important positions. In another case, from Judge Ali, of course, and Harper versus Bessent. Now, the only decision to reach contrary conclusions are for officials who had no removal protections, who had no property rights. Now, even if the loss of her position itself is not irreparable harm, it's not, the president's for-cause removal of Lisa inflicts irreparable, reputational, and stigmatic harm. Pathetic. In a related context, they said, well, the DC Circuit says if there is a stigma, then that can implicate critical liberty interests. Unlike Dellinger or any other principal officer, she has been targeted under auspices of alleged wrongdoing in the paper and a criminal referral from an executive agency. These allegations pose a serious risk of tarnishing her standing among economists who already think she's a joke and the American public, and making it impossible to take advantage of other employment opportunities in the future. She's already been outed, man. So I guess now it's like you have to keep her in that position because Trump damaged her. So she can't get a job somewhere else. So now you can't get rid of her. Indeed, there is a risk that the Federal Reserve could refuse to reinstate Governor Cook. The only way to clear the cloud over her name is to immediately reinstate her. And this is also extraordinary because she's been deprived of her guaranteed process. Accordingly, the court has repeatedly held that she should have been heard. And if you allow Trump to get her out of this position, even temporarily, that would amount to a crack in the foundation of the Federal Reserve's near century of independence. And that is a bell that could not be unrung, even if she were ultimately reinstated. And so closing this out, she says, all of this weighs in favor. This is pretextual. We've had political independence for 111 years, and Trump is trying to get her out. Congress has the national interest at stake, and they spoke about this, and even public markets, they're talking about the stock market, have reflected and reiterated the desire for independence in the aftermath of the Trump decision. And the nation's leading economic periodicals all echoed their support for a mortgage fraudster. It was like 450 economists or something who all signed some stupid letter. And we know that people who sign letters like that generally, right? We've seen the 51 intelligence idiots who had no intelligence at all saying Russian hallmarks. Give me a break. So accordingly, the public interest supports preserving the stability that the Federal Reserve has established, and we want you to shove her back in power. Signed by Abby Lowell in a pretty tedious filing here from the Lisa Cook defense team. Now, Bill Pulte is asking a very serious question. Okay, why hasn't Jerome Powell come out and said that Lisa Cook's conduct is not representative of the Fed? Maybe because it is representative of the Fed, all filled with fraudsters. And this case is progressing forward. We see they also filed a joint status report. And in this joint status report, you can see they're not getting along here. Okay, the DOJ, Trump, of course, being sued by Lisa Cook, they submitted this to kind of flesh out what's coming next. They write, all right, we're writing this together. Now, we agree that Lisa Cook will file her reply, we just read it, and then the government will submit a supplement tomorrow, which we'll look at. Plaintiffs believe, Lisa Cook, that the court indicated that Lisa could file another reply. And if so, that's going to come back down on the 5th, Friday. Now, Trump does not concur in that interpretation of the transcript, okay? You should not get another response. Generally, what you have is a motion, a response. So Lisa Cook files the motion for a temporary restraining order. Government files a response to the motion. Then she files a reply. That's the end of the sandwich, okay? You're done, should be done. We get a little supplemental brief that was permitted, and then she's saying, can I have a surreply to respond again? Now they're battling over that. So they say, we don't think she's entitled to a third brief in support of her pending motion. She already got two. We're filing a supplemental because you asked us to, but she doesn't need another response to our supplemental. But beyond the question of further briefing, we do not agree on the appropriate next steps. Now, Lisa believes the court should grant a TRO to preserve the status quo and then move for cross motions on the merits. And they propose a schedule whereby motions would be filed September 9th and 15th. We have hearings very quickly. Now, in practice, an expedited summary judgment proceeding may not require much more time than the defendant's, Trump's, preliminary injunction preference. But Lisa believes that any discovery issues, if there is discovery, can be resolved expeditiously and would obviate the need for either party to invoke federal rules of civil procedure. And as the court noted, given the issues involved in this case, a decision on the merits would result in a complete record for speedy appellate review. And so here's what Trump says. We think that there could be 3 stages of briefings, but Lisa only wants 2. Trump says that given the parties and the court's engagement in the legal issues presented by the emergency relief, they say the court should treat Lisa's TRO as a motion for a preliminary injunction. Okay, it's not a temporary restraining order. It's a preliminary injunction. You want it to be permanent, so let's just do it. We don't need to do this twice. We don't need redundant briefing, and it's not going to require any additional briefing now. Now, defendants do not agree, Trump, that expedited summary judgment is even possible at this stage. Although the legal questions relevant to Cook's request for emergency relief will be briefed by September 4th coming up, the issues likely material to any summary judgment proceedings, which would resolve the case, right? You win, you lose, include factual questions, and so we need discovery. For example, whether Dr. Cook had actual notice of her potential for-cause termination. Like, did she get the Truth Social? Did somebody text her about it? Of course she got notice. And the underlying facts giving rise to that termination. So we gotta know. She says, I didn't get notice. I had no due process. Yeah, you did. You didn't? Well, come in here. Let's have a deposition and see what you have to say. And give us your cell phone records, because we know you got texted from that. Probably Jerome. He's like, oh, we're in big trouble. Any summary judgment motion would be premature at this time. And so accordingly, Trump says the court should treat her motion as a preliminary injunction, adjudicate that motion, and stay further proceedings pending any appeal. And we further request that you also adjudicate the other motion before the Federal Reserve's next meeting, right? The clock is ticking on this thing too. September 16th, coming up soon. So Abby Lowell signing that. And look at all these people, man. It's Abby Lowell, all right? And guess who else is on here? Norm Eisen, the Democracy Defenders Fund. It's like, man, these two peas in the pod representing a mortgage fraudster, representing Tishy Tish, representing Hunter Biden, Abby Lowell, all of them, and someone else. I think someone else who just got fired, whatever her position was. She went and hired him too. So that's coming up soon. We had a great comment on our locals this morning. I think you may have seen it, but it's really relevant to what we're talking about here. Our friend Turbo Encabulator is saying, I was looking into Lisa Cook, and look what we got here. I was watching a video about Lisa Cook and her Ann Arbor property, where she claimed primary residence on mortgage documents. So I looked up the county tax assessor record record and found that she also claimed the principal residence exemption for this home, 2024, 2025. So she's not living there, but she's getting tax benefits. The worst part about it is, what is that principal residence exemption? What is it for? It's a property tax that goes to the schools and the school districts. So she cheated out the schools of $5,700 over 2 years by claiming this exemption. She's taking from the kids. Look at that right there. Looked it up. 25, 24, principal residence exemption is a percentage, 100%. Shout out to Turbo Encapulator for digging that one up. Hopefully Bill Pulte is listening to the show today. Speaking of Bill Pulte, here is the man himself. He posted this when he was outside talking to the cameras. C-SPAN says that he is saying, if you're going to be in charge of the Federal Reserve, you better know how to fill out friggin' paperwork.
Because once we dug in more, we found more. And anytime we find more, whether it's on a criminal suspect or otherwise, we try to report it to people. So we reported it to the DOJ. She said that she had a second home, but then in her disclosures to the U.S. government, she called it an investment in rental property. Investments in rental properties are different than second homes. And back in that time frame, 2021, where she took out these 3 mortgages, you had different rates for these different types of classifications. So it's very concerning, and the DOJ will have to figure out what they do with that.
Do you think the president or the administration is going to name her replacement while this litigation is ongoing?
I have no clue. You'd have to ask the president that. My main focus is on getting rid of mortgage fraud and finding mortgage fraud no matter who commits it. If they commit it and we determine that it's within our purview, prosecute it, we will refer it over to the DOJ, and that's what I'm singularly focused on. So,
are there other government officials who are looking into the mortgage fraud?
We're looking at a lot of different things. We refer criminally people every day, contrary to what people say. We refer people who are Democrats, Republicans, it doesn't matter. But we're not going to be deterred from pursuing people. But the ones that we've made public or have been made public by other people are the only ones that we're prepared to talk about right now.
Tom Dempsey with News Nation. The attorneys for Ms. Cook are saying this is all just an effort to get interest rates lowered and that there was never cause to begin with for her to be fired. What do you say in response to that?
Well, Ms. Cook is the one who filled out the applications, not me and not anybody else that I know. So she needs to account for, why did she take these 2 mortgages out? She took out a Michigan loan, and then 2 weeks later she goes and she takes out another loan for a property in Atlanta. She declares both of them as her primary residence. Then you go back 4 months from that, she took out another loan. We're now finding on a third property, saying that it was a second home when really she declared it as an investment property.
Convenient.
So, this really has nothing to do with the Fed. It has much to do with public officials. If you're going to be in charge of the Federal Reserve, damn, you better sure know how to fill out a mortgage application. And boy, it's awfully weird that she potentially saved a lot of money by making so-called clerical errors, which were not clerical errors.
Do you know if she's still getting paid by the Fed or how that's working while you guys bring this?
I don't know, but Jerome Powell, he's got to answer for why he's not coming out and saying this is bad. He's destroying the credibility to the Fed by not saying that mortgage fraud is bad. I mean, we have great career people. We have great people at Fannie Mae and Freddie Mac. We have great people at the Federal Housing Agency. Why would somebody who's Jerome Powell not come out and say, you know what, if Ms. Cook did this, she should resign? So it's becoming more and more concerning by the day. And I say that because, not only from a legal perspective with mortgages, but obviously the mortgage market is very dependent on the credibility of the Fed. And so it's concerning.
And she's also stealing from the youth of America. So Lisa Cook, she sounds shook. I think that they are realizing that the weight of the Supreme Court precedent is anchored against them. And we've seen that in the recent decisions that have been coming down from them saying Trump does have this power. A lot of these independent bodies are getting a reckoning. And now we're at the Federal Reserve knocking on their door. The final boss, level 10. Let's go.